This is the demonstration of how the memory charts created by Lexcampus works. Now, this is for amendment of applications and specifications. The relevant sections are 57 to 59 and section 15 as well. We'll see how it is relevant. Then the relevant rules are rules 14, 57 to 63, which deal with the procedure for opposition, and 81 to 83, again rules which deal with the amendment of a specification. And the form that is relevant is form 13. Now we have a time axis, and in the time axis we have two things that happen before the grant and things that happen after the grant. We also have a place axis as to where the amendment can happen. The amendment can happen at the IPO or at the Intellectual Property Appellate Board or at the High Court. Now let's see the provisions. Now section 51.1 deals with amendment, how an amendment can happen, and the form relevant is form 13. Section 51.1 clearly states that there cannot be an amendment pending infringement or revocation. That's a point to be noted. Section 57.2 talks about leave to amend. Now this can happen at any time before or after the grant, because there are two types of amendments. And once the leave to amendment is filed, the amendment has to be published. Once it is published, the request to amendment is published, there can be an opposition can be filed, and the relevant rules for the oppositions are mentioned in the green box. And then the controller has the discretion to ask for certain amendments. These are the amendments at the discretion of the controller. Now this is where section 15 comes in, and we have put section 15 in the box. Section 15 is a provision that is related to section 57.6, because under section 15, a direction can be issued by the controller to amend, and the amendment would happen under this provision. Now, there are things that happen at the IPAB. Now, for instance, section 58 talks about amendments at the IPAB or at the High Court. There are provisions for cost, advertisement, and amendment in a proceeding before an IPAB or the High Court is done to avoid revocation. Again, because this is a proceeding that happens at the IPAB or at the High Court, notice has to be issued to the controller, and there are provisions that regulate that. And copies have to be sent to the controller, and the register has to be corrected depending on the amendment. Now 59 states that the amendment shall be a part of a specification, and amendments have to be published, and an amendment cannot be questioned unless and until there is fraud. So you can only question an amendment if there is fraud. Amendment can also be an amendment to the priority date, and whenever there is an amendment, you have to construe the original in interpreting the amendment. So you have to go back and look into the original document or the original specification as it was originally filed. Now, apart from these, we have some additional points. What can be amended? An application for patent can be amended, a complete specification can be amended, and any related document can also be amended. Who can amend? Two people: applicant before the patent is granted, patentee after the patent is granted. And how to amend? Amendments can be only of three types. It can be by way of a disclaimer, by way of a correction, or by way of an explanation. And the scope of the amendment is you can actually cover actual facts and fair basis. Fair basis is a principle. That's why we have put that in inverted comma. We have explained that in our separate videos. Fair basis is the fact that your amendment should be in line with what you have disclosed. You cannot introduce any new matter. Whatever you amend should be fairly based on your earlier disclosure. Now, this itself, as you see now, is a memory chart. So apart from watching this video, you could also use this memory chart, which we will give in a PDF format, for revising and understanding the entire provision. We strongly urge you to use this memory chart along with our videos, because the videos have the more detailed explanation of all these provisions.